Of the people, for the people, and by the people. The Indian Constitution, the longest of any sovereign nation in the world, provides a comprehensive framework to guide and govern the country, keeping in view social, cultural, and religious diversity. Hello and welcome, viewers. You're watching our special presentation on major constitutional amendments that changed India. As of October 2021, there have been 105 amendments of the Constitution of India since it was enacted in 1950. One of the strengths of the Constitution is that it is a dynamic instrument that can evolve with time by amendments. An impartial judiciary, independent of the legislature and the executive, is one of the main features of the Constitution. The Supreme Court of India is the highest court of the country and acts as a guardian of the Constitution and serves as the final court of appeal. There are many autonomous institutions set up under the Constitution which perform a key role, such as Election Commission of India, responsible for holding free and fair elections, Public Service Commission, responsible for selection to main government services, and an Auditor General for independent audit of accounts of the government and its agencies. Another novel feature of the Constitution is that it contains a chapter on the directive principles of the state policy that are in the nature of directives to the government to implement them for establishing social and economic democracy in the country. These principles are considered fundamental in the governance of the country.
Take a decision in common and march in a cooperative way on that road which is bound to lead us to unity.
Article 368 of the Constitution deals with the power of Parliament to amend the Constitution and its procedures. It states that the Parliament may amend the Constitution by way of addition, variation, or repeal of any provision in accordance with the procedure laid down for the purpose. However, Parliament cannot amend those provisions which form the basic structure of the Constitution. It provides for two types of amendments, that is, by a special majority of Parliament and the special majority of Parliament along with the ratification of half of the state's legislatures by a simple majority. Under Article 368(2), Parliament can amend the Constitution by passing a bill with a special majority. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament, Lok Sabha or Rajya Sabha, and not in the state legislatures. The bill can be introduced either by a minister or by a private member and does not require prior permission of the President. Each House must pass the bill separately. The President must give the assent to the bill. The President can neither withhold the assent to the bill nor return the bill for reconsideration to the Parliament. After the President's assent, the bill becomes an act, that is, a Constitutional Amendment Act, and the Constitution stands amended in accordance with the terms of the Act. Today we'll take a closer look at the Constitution Fifth Amendment Act, enacted in 1955. It amended Article 3 of the Indian Constitution, which provided Parliament to effect, by law, reorganization inter se of the states constituting the Indian Union. The Fifth Amendment of the Constitution re-enacted the proviso to Article 3. The President was given the power to set a deadline for state legislatures to submit comments on proposed central laws relating to the creation of new states and changes to the areas, boundaries, or names of existing states by the Constitution, Fifth Amendment Act 1955, the formal name of the Fifth Amendment Act of the Constitution. The original Article 3 was so drafted because of three main reasons. When it was drafted, the princely states had not been fully integrated. There was also the possibility of reorganization of states on linguistic basis. Constituent Assembly had foreseen that such reorganization could not be postponed for long. Article 3 was incorporated in the Constitution, providing for an easy and simple method for reorganization of the states at any point. When it was discovered that the initial version of Article 3 did not include a deadline for the states in question to voice their opinions, a problem developed. The absence of such a constraint could slow or even halt parliamentary legislation intended for the stated goal.
The Union of India is a federal union with the distribution of power among centre and the state governments. The states and the territories thereof are as specified in the first schedule of the Constitution. However, at the time of commencement of the Constitution on 26th January 1950, the territories of the states were not frozen for the simple reason that the princely states at that time were not entirely united, and also there were chances that the states would need to be reorganized on linguistic basis. Therefore, Article 3 empowered the Parliament to make law to form a new states by uniting two or more states, or by separation of territory from any states, increasing or decreasing area of any states, or alter boundaries or names of any state. The article was designed in a way that enabled Parliament to maintain the concept of federalism.
The amending act therefore made it possible for the President to set a timeline through which the Parliament could proceed with the matter with the views of state concerned. This amendment made the proceedings regarding reorganization of states efficient, and this propelled the states to check on the issues related to them responsibly. After the amendment, the procedure was changed and the exercise of this power by the Parliament was subjected to the following conditions. A bill for any such purpose cannot be introduced in Parliament except on the recommendation of the President. If the bill affects the area, name or boundaries of a state, then before recommending its consideration to Parliament, the President has to refer the same to the state legislature concerned for expressing its views on it within such time as he or she may fix.
When certain proposals for reorganizing some of the states are under consideration of the central government, it was realized that Article 3, as originally enacted, did not include a deadline for state to express their opinion or concern on its reorganization, and delay on the part of the state governments was delaying parliamentary legislation in reorganizing the state. Therefore, the Constitution 5th Amendment Act was passed by the Parliament, making provision that the President, while seeking a recommendation of the state legislature, may specify a deadline or prescribe time limit for seeking opinion of the concerned state. The main objective was to reorganize the states on linguistic basis without an undue delay. Article 3, after the 5th Amendment of the Constitution, now specifies that the President may refer the bill to the state legislature for their input, which should provide it in a time-bound manner mentioned in the reference, or any additional time that the President may grant.
Article 3 gave Parliament the authority to pass a bill of reorganization. But to pass it, the bill first had to be passed by the state legislature. The purpose of the provision was to give an opportunity to the concerned state legislature to express its views on the proposals contained in the bill. Parliament was, however, in no way bound by these views. All that is contemplated is that Parliament should have before it the views of the state legislatures affected by the proposals contained in the bill. But the Parliament is free to deal with the matter in any manner as it thinks fit and may accept or reject what the state legislature says.
Though we are a federal structure, but when it comes to the reorganization of the state, either carving out a new state or merging two states or altering boundaries of the states or changing their name, I make it clear that the Parliament is supreme. Only requirement even after the amendment of Article 3 of the Constitution, which empowered the Parliament to reorganize the states, is that it will seek a recommendation of the state legislature in a time-bound manner. The President will make a reference to the state can give its views, but the views received from the state legislature are not binding on the Parliament. Therefore, in spite of the fact that so far as the powers, distribution of power between the center and the state is concerned, the Constitution specifies in list 1, 2 and 3 how those powers are to be exercised. But when it comes to the reorganization of the state in the Union of India, the Parliament of India is supreme as to on what basis the state should be carved out. And as I said earlier also, in the year 1956, when the states were reorganized, the basic objective of reorganizing the states were on linguistic basis. And prior to that, it was generally because the princely states were not really organized in that way. Therefore, there was a need.
The first state to be reorganized after 1947 was Andhra Pradesh. It was separated into Madras and Andhra Pradesh. Confusion arose over the meaning of the expression "express view" of the state legislature. Due to this, number of court cases resulting from the violation of Article 3 increased. So the Supreme Court solved this problem in the case of Babu Lal Parathe versus the state of Bombay. To conclude it all, we can say that the 5th Constitutional Amendment Act came to be of help and has played an effective and efficient role in reorganizing the states as per the need. Henceforth, the amendment, which brought in the clauses related to time limit, helped in persuading the state governments as well as the Parliament to seek the attention in the matters related to state reorganization. Well, viewers, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.